All right, David, Lauren, Matt, and David, your client is on Zoom.
Good.
All right, let me see if I can get him to unmute and start video.
There you go. Thanks, Jose.
Yes,
Hello, Mr. Cavazos.
yes, ma'am. Hello.
Hello.
Sorry about that. Not
Oh,
being on here
no.
on time.
Oh, no, that's not a problem. You know what I've
Yeah.
discovered?
What's that? No.
When COVID was hitting and everything was shut down, people didn't know how to do Zoom. Then we learned how to do Zoom. And then when we stopped using Zoom so much, everybody forgot how to do Zoom. So it's
Well,
fine.
it wasn't that. It was that 1 hour time.
Uh-huh.
Here it's only after 8 o'clock.
Oh, okay.
So I kept thinking, okay,
El
well,
Paso.
I still got another 30 minutes. Yeah, I'm in El
Okay.
Paso right now at a halfway
All righty.
house.
Maria, are you ready?
I'm ready, Judge.
All right, we're going to go on the record. Court is calling 210 CR 5796. And this is in the case of Jose Cavazos. Could I have parties announced for the record, please? For the defense or the appellant?
David McLean for the petitioner, Jose Cavazos.
And representing the state?
Lauren Samota for the state, Your Honor.
And Matt Howard for the state, Judge.
All right, and we have Mr. Cavazos here as well.
Yes, you do.
All right, is there any objection, Mr. McLean, to having this hearing by Zoom?
Absolutely not, Judge.
Mr. Cavazos, do you object to having this by Zoom?
No, ma'am, I did not.
All right, and Ms. Zamora and Mr. Howard, do you have any objections to having this hearing by Zoom?
No, Your Honor, no objections.
All right, so what we're here for today, both parties had filed a brief. State you had filed a memorandum. The court has reviewed both of those documents. State, do you have any evidence you wish admitted?
Yes, Your Honor. I've conferred with Mr. McLean. There are 6 documents that are marked that we have conferred, and he has no objections on. I will name those for the court. State's Exhibit 1 is the indictment in this case. State's Exhibit 2 is the waiver, and this that contains the stipulated evidence that Mr. Cavazos entered into at the time of the plea. The third document is the lab report from January 6th, 2010, which was part of the original investigation. State's Exhibit number 4 is the sorry, Judge, that is the, I believe I'm not sure what 4 is. I'm sorry, Judge.
Just
Okay,
one moment,
make a motion.
just 1 second. Maria, can I see the exhibits, please?
Yes, Judge.
State's Exhibit 4 is the waiver.
Okay. Judge, 4 is the
Just a moment.
oh, sure, Judge.
All right. I was just having Maria hand me the exhibits. I had tendered her the exhibits because you all had previously agreed that they would be admitted.
Yes,
That's
Judge.
correct, Judge. Petitioner agrees.
All right. So State's Exhibit number 4 was the court admonishments and defendants' waivers and affidavit of admonitions, correct?
Correct, Judge.
All right. And you may continue.
At number 5 is the Bexar County Crime Lab report from November 1st of 2023. That would have been in regards to this Chapter 64 hearing. And number 6, Judge, is the state's amended response.
Judge,
And so we would ask those be entered into evidence as part of this hearing.
Your Honor, we've reviewed that. We've conferred with the state on that. We have no objections to states 1 through 6 being admitted.
All right. Then State's Exhibits number 1 through 6 is admitted without objection. Any other evidence or admissions, State?
No, Judge, not from the state.
All right. Defense, do you have any evidence?
Judge, other than what we have provided attached to our brief and that we supplied in our hearing that we held on this matter, I don't think that the defense has any further evidence. We would stipulate that the entire record is part of the court's purview in this matter. I believe the state and I had conferred regarding the admission of the PSI report, as well as the transcripts from sentencing. I don't know if we've been able to locate those at this time. But we would ask the court to incorporate those into the court's consideration as well, being is that they are part of the record. And I believe the case law is pretty clear that the entire record is before the court.
All
Yes,
right.
Judge, we have no objection to the plea transcript. We have not received that yet, but we will get that to the court, since that is part of the court's file, as well as the PSI, which the court took into consideration. I believe we will have to get that from probation. So we can get those two items to the court, as soon as we can.
All right.
But otherwise, in terms of a hearing or any other evidence to present today, we don't have anything else to present.
All right, so the PSI report, I'm thinking if that was preserved by probation, that should be easy to obtain. The transcript of the plea, we'll have to discover who the court reporter was, and I think that may be easy to discover. I think it may be listed. It should be listed somewhere, either on the judgment of who transcribed it, or either the court will be able to figure out who the court reporter is. And what I'll do, if there's no objection, I'll see if I can discover who the court reporter is. I'll ask the previous judge who their court reporter was. And I can see if Maria, the current court reporter who's in here, knows who the court reporter was. So I'll see if I can help discover that for you all, if there's no objection to the court trying to discover that.
No objection, Judge.
No objection, Your Honor.
All right, then the other thing is, I don't know if there were CPS records, and the CPS records may have information. It may have information concerning the DNA or other statements that were made. I'm unsure because I don't know the relationship or the alleged relationship, Mr. McLean, of your client and the complainant.
Judge, I would only say the only thing that we did not discuss with Mr. McLean on this is, and I don't want to go, I think, I don't know that would be, I don't want to go against the court, but I don't know, that was not part of the original proceeding. It's not part of the court's record. So because this is a Chapter 64 hearing and not a writ of habeas corpus, I don't necessarily know if CPS records, because they weren't part of the stipulated evidence or entered at any part in the trial, I don't know if that would be outside the record and inappropriate for a Chapter 64, and maybe more appropriate should Mr. McLean choose to file a writ as a result of the findings on the Chapter 64. So I just wanted to bring that to the court's attention. So that's kind of the only objection that we would have, is that I just don't, what really we don't want to do is later on other cases be trying to get in evidence that would be detrimental to the defense in any case. But in this case, I don't necessarily know that it needs to be considered, as it wasn't part of the original proceeding. So I'll let defense talk, and I don't know if Judge, if you have any questions on that.
Yeah, the only reason why I bring that up is because in State's Exhibit, excuse me, in State's Exhibit number 2, on, I don't have page numbers for it, but it is the first page of the stipulated evidence. One of the witnesses listed is Child Protective Services. And so I don't know, because I haven't read the stipulated evidence from the trial court. I don't know if there was some mention other than this person's name in the stipulated evidence or not, because I haven't read State's Exhibit number 2 yet. But if you all want to read State's Exhibit number 2, and if both of you all decide that, yes, it was a part of the record, it is in the stipulated evidence, then I guess we can cross that bridge when we come to it. I don't know for sure if it's in the record or not, because I haven't had an opportunity to read State's Exhibit number 2 yet.
Sure, Judge. And we will read it. I think I've read it. It contains the sane notes. It contains the outcry statement, contains medical records. I don't think there's anything other than some the initial I think it mentions her because she was there at the hospital when the child came in. But other than that, I think it would be in the plea transcript or the sentencing transcript, if it was mentioned in there. So if it for some reason is in the record, we have no problem providing it. But that was our concern, is that it's not inside the record and we don't want to go outside the record.
No, I don't want you all to go outside the record either, but I guess we'll know more.
Judge, I've reviewed it. And I agree, there is no CPS records attached in the stipulated evidence. I don't see anything with any statements from a CPS caseworker. Yes, they had her listed as a potential witness, but they did not, there's no evidence in the stipulated evidence from that person, other than just her name being listed in the police report.
All right,
And
and I'm
so-
reading through the stipulated evidence as we speak. Just give me a moment. It won't take me that long.
Sure, Judge.
No problem, Judge.
All right, and State's Exhibit number 2, the court only sees the mention of the CPS worker's name and the fact that a CPS worker was called by a teacher. So that's all that I see in State's Exhibit number 2. I read it rather quickly. Does anyone see anything other than what I've just stated?
No, Your Honor.
No, Your Honor.
All right, then, so it will ultimately depend on what was presented at punishment. And I don't know what was presented as punishment, so we'll need to get that transcript.
And Judge,
Um,
just for the record, I did a little quick research while we were talking here, went back into the record. It looks like it was Judge Angelini's court reporter, Bettina Williams,
All right,
who did the transcript back in the day.
all right, well, I still have Miss Williams' contact information.
Awesome.
Do y'all have any objections to me reaching out to her? Because I know she's retired,
Yeah. No,
and I
have
could
no
see if
objection,
she
Judge.
can get the record for us.
No
I would
objection.
appreciate it, Your Honor.
All right, so I'll get in touch with her today, and I will give her the name. Does anyone have the date of sentencing?
Yes, Judge, I'll get that for you right now.
It's like October 4th of 2011. Is that right?
I believe so. That's why I knew it was in October. Just checking the
October 4th,
dates.
2011 sentence. Yep.
Yes, that's right.
All right, I'll ask her to provide a record for it, and I'll include you all in the email that I sent to her, and then she'll make sure it's in an email format to send to each of you.
Thank you, Your Honor.
Thank you, Judge. And
All
Judge,
right.
it looks like August 5th, 2011 is when the actual plea was taken.
Okay, August 5th, 2011, the plea, and October 4th, 2011 is sentencing. I'll
Yes, Your
ask her to provide transcripts for both the sentencing and the plea. Is there anything else with regards to this case you all would like a transcript of?
Not from the
I don't
state,
think
Your
there
Honor.
is anything else, Judge. No, I don't think there's anything else. Thank you, though.
Now, with regards to expert witnesses, does anyone feel the need to have an expert witness present as it relates to DNA?
Not from the state, Your Honor.
And Judge, we've conferred with the state. We do not. We've both stipulated to the admissibility of the results from the lab. In this particular case, given the fact that it was pretty inconclusive and there was an exclusion by my client, they don't have all the data with the alleles and just all the crazy stuff that comes in these reports. It's pretty self-explanatory for the court. So I don't think that there's any real need for an expert to come in and tell the court what is in pretty plain English in the report.
Are both parties in agreement with Mr. McLean?
Yes, Your Honor.
Well-
I'm sorry, Mr. Howard, go ahead.
And hang on, I do think we may have two different views of the plain English within the report. I guess I should say. So we, as far as not needing the expert, I think that that's probably fine. But I do think that we both have argument as to how the court should interpret those results.
All right. If you all have arguments for my interpretation or results, do you all think it's best that an expert be present at the hearing to give their opinion of what the results actually mean? Although I know in the stipulated evidence, it seems that it's easily interpreted by someone who's not a DNA expert.
Judge, I don't,
I don't
think
think that we need one, but it's up to the court, Judge. If you think that the court needs some guidance on it, we're happy to do that.
sure, Judge, and that's the same with the state. I think it's, I think and I'll just put it in plain English. We said it last time, Dave. I think the only disagreement we have is, Mr. McLean says excluded, and he is excluded, but he's excluded as a female donor. And I think that's the plain English that we're talking about. So yes, is he excluded? We can all agree that that's what the plain English says. It's just, what is he excluded from? And I think it's clear to the court, it says there is a female. So that's, I don't necessarily think we need an expert, unless the court would like one. But in my opinion, I think it's pretty plain what it says. So I'll leave that to defense since it's their motion.
Well, here's my question. Is there an agreement among the parties that he's excluded based upon the fact that the DNA expert is saying that a donor was a female?
We can agree that he's excluded as the female donor, that he's not the female donor there on the DNA, but we will not agree that that exclusion means that he is otherwise exculpated. And I think that's clear in Ms. Zamora's response and in the memorandum that she filed. But if you would like us to have an expert come in and talk about what that means, we can certainly do that. If you'd feel more comfortable with that, Judge.
Well, I think a layperson would think that he's excluded as a female donor. But the question becomes, Mr. McLean, whether your argument, and I don't want your strategy or what your argument will be, if you don't want it known to the state, if the argument is going to be that exclusion means he's excluded, period, to everything, then we probably need an expert to come in to say he's excluded. He's excluded because this is a female donor and he's not female. But if someone is going to interpret that as he's excluded, period, then it would probably be best to have an expert here to say, no, he's excluded because he's not a female and this is a female donor.
Yeah.
So I'm just going to leave that there. Then if
Sure.
somebody thinks that the interpretation that I've just given, that's not what that means, then you probably will need to have your expert here to say that, if that's what the expert will say.
Frankly, Judge, I think you nailed it. I think that's exactly what the result says. I think it's actually kind of what Mr. Howard's saying. And I think that's essentially what we say in our brief as well, is that he's excluded because he's not female for the one sample that they've got. They run another sample through the YSTR and it comes back inconclusive because there's not enough DNA sample to determine anything from it. And so basically we end up with an exclusion because he's not female and an inconclusive because there's not sufficient DNA to do the testing. Both of those result in no DNA identifying Mr. Cavazos. That's our position on it.
Right, and is everybody in agreement with Mr. McLean's rendition of what the report means?
Yes,
That-
yes, Your Honor. I believe that is exactly what it means, what Mr. McLean said, yes.
All right, if both parties are in agreement, that's what the report means, and no one is going to come to the final hearing and say it means something other than what we've just stated, then maybe you don't need an expert. But if someone decides to change their opinion on what we just stated on the record today, then you're probably going to need to have an expert come in. And that expert, if all parties agree, can be present by Zoom.
Okay. That we agree to that, Judge. Thank you.
All right, so what I'm going to do is, Mr. Cavazos, I'm not going to give anybody a setting today because I need to reach out to the court reporter to have her find the transcript. And then I need to see how long it's going to take for her to prepare the transcript. It may be short, depending on if witnesses were called or not. I don't know. And I know some of us do not know if witnesses were called or not. And then I'm going to do that today. And as soon as I have the information from her, I'll email all parties to let you know she's found the record. This is how long it's going to take for her to prepare the record. And then I think both parties have agreed, unless there is something in the sentencing where a CPS worker was called to give testimony, we may not need to delve into CPS records. Is that correct?
That's correct, Judge. And I would advocate that those CPS records are not part of the record if they were not produced in evidence. And so we would reject any CPS records coming in. I think it's
All
outside.
right. So we'll have to see what was done at sentencing. And then once we have a transcript for sentencing, if you all read it and there's a CPS worker is called, I'll still leave it up to the parties if you feel as though the court should be reviewing CPS records. And if all parties say no, we believe that's still outside the record, then I will strongly consider that and probably not review CPS records. So is there anything else that you'd like to place on the record, Mr. McLean?
I don't think I've got anything further, Judge. Not at this time.
State anything else?
No, Your Honor.
Nothing.
All right, we can go off the record, Maria. So, Mr. Cavazos, I know that this is taking some time. A lot of the time was spent because the DNA needs to be tested. But I believe the state and the defense will tell you, I don't like to leave any stone unturned. And I think both parties want to get to the bottom of everything. So sometimes that takes time because I want to be thorough so that once this is resolved, it's resolved.
Thank you for that.
All right. So as soon as I'm able to get the transcripts, I'll let all parties know. Hopefully it'll be quick. And then once I obtain the transcripts, we can set it for a hearing, and I'll let you all coordinate with the court coordinator for when we can do a hearing. And if there are no objections by any parties, of course, you can appear by Zoom if that's easiest for all parties concerned.
Thank you, Judge.
Yeah, it would be easier for me because, like I said, we're in El Paso, so.
All right. Yes, we'll make sure that it's done by Zoom for you, sir.
Okay, thank you.
All right. You are welcome. All
Yes,
right.
and-
And yes, you may be excused, Mr. Cavazos. Thank you.
Thank you.
Thanks, Jose.
All right. So everyone else, I know there was other stipulated evidence that was admitted at other hearings. So I'm going to see if I can get the court reporter to give me copies of that because we now have a different court reporter, not the same court reporter who did that. However, if y'all have copies of the stipulated evidence, and you want to email it to me, that would be great as well. And
Okay.
I'm going to make sure that Maria has the exhibits that you've admitted, but I'm also going to have copies made so that I'll have the copy. All right. Is there anything else
Nothing
No,
further
Your Honor.
from the petitioner, Judge. I think
All
that's got-
right.
Okay.
And after, I'm sorry, after the transcripts are given to the court and I give them to you all, if y'all want to make any additions to your argument, just let the court know. I'll give you time to do that.
Thank you, Judge. I
Thank you,
appreciate
Your
it.
Honor.
All right. Thank you, guys. Thank you so much for appearing by Zoom. Have a great rest of your day. It's Friday.
It is.
Yes.
Have a
Have a great
weekend,
weekend, Judge.
See you,
All right.
Maria. Thank you.
Thanks.
Bye.
All right. Bye,
Bye,
guys.
y'all have a good day.
You too.
All right. So we're going to take a recess.
Nicholas Cruz.
Page 12, Nicholas, come on up.
And they have it backwards on the docket. They have it Cruz Nicholas.
Yeah, so, yeah, we need to do a name change. Are you Nicholas Cruz? Mr. Cruz, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Just so you know, you're not here alone. Your lawyer's here with us on Zoom, just the TVs aren't working, otherwise you'd be able to see it. All right? Okay.
August 11th, 2024, officers were dispatched to a drive-by shooting at a little bit after midnight. Officers received a description of a black Jeep with blue lights on the wheels and a light bar on top of the vehicle. Officers observed 2 spent shell casings on the ground at the scene. Officers located the vehicle, returning to the location and conducted a traffic stop. They located a AR pistol, a Taurus located in the floorboard, and a box of ammo in the front seat of in a backpack. The defendant is 18 years old. Your Honor.
Was he the driver? Was he the shooter? What happened to the other person? I'd sure
No.
like a lot more info.
Stop.
And what kind of damage was there? Did they hit the house? Any damage?
You don't have any information about the damage. Your
Ms.
Honor?
Cruz. There's an AR, drive-by shooting.
They found a pistol, Judge, it was an AR pistol, and
Yeah.
there's nothing in the DIMS that indicates that they investigated anything other than a UCW.
Shame.
Following up on this one, but.
Yeah, I mean,
At this point.
you're lucky you're not charged with multiple felonies with this. I'm sending you for a drug test right now. I want to know what is in your system, and then you must come back. Do you understand? If you don't come back, life's not going to go well for you, because I'm going to make your bond sky high, Mr. Cruz.
Here it is, Your Honor. A witness explained to the
No.
officer that moments
Stop.
prior, a black Jeep in color with blue lights passed his home and began shooting. The witness stated he did not see the driver aim at him or his home, but was just driving by and discharging rounds into an open lot.
Yeah, I mean, hey, Eric, we need to talk more about this when he gets back. I want to see what, if anything, is in his system. Do you want to chat me your cell phone number? And then when he gets back here, I can reach out to you and we can talk more.
Yeah, Judge, I have your cell. I'll shoot you a text.
Say that again?
I said, I have your cell. I'll text you right now.
Okay, thanks. I'll chat you when he gets back here. Yeah.
Page 2, Arita Jefferson.
What's your first name?
Jefferson.
Is it with one F or is it with two?
One F.
Okay. Mr. Arita, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine. we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On August 10th, 2024, officers conducted a traffic stop on a Chevy Silverado for having no front license plate. During the course of the traffic stop, they observed the back license plate to come back to a 2004. The defendant stated that he had gotten the truck from his friend's house and drove it to a gas station. He stated he traded another car for it.
Mr. Rita, I'm going to find that there's probable cause to go forward with your case. How old are you, sir?
I'm 18.
What do you do for a living? Who are you here with today? Do you have a Texas driver license? You're not allowed to drive. I don't care what's going on in your life now. If I find that you drive, I'm going to put you in jail. You will not get any more PR bonds. Do you understand, sir? Do not drive and don't have any more weapons, don't have any weapons as a result as well. This is an affidavit. This is a promise that you're going to make to me that you're not going to drive. If I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail every time you drive because it's an offense in and of itself. So if you drive 5 times, I will have 5 different contempt hearings. Do you understand? Did you graduate from high school? That's what we're going to work on now. You will work on that with me. I will provide you a lawyer today, but I'm bringing you back in 2 weeks and I want to see what you have done to start working on your GED or get back into high school. If you haven't done anything, then life is not going to go well. Do you catch my drift? I'm going to have you go to Victoria, sign a reset. After that, we're going to give you an application for an appointed lawyer, and then I'm going to have you take a seat in the jury box.
All right, Judge, next is page 4. Butler, Stephen, come on up.
What page?
Page 4, Butler.
Right now, we're just worried about one thing at a time. Yes, sir.
Right. Good morning, Mr. Butler.
How you doing?
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On August 11th, 2024, at approximately 1:22 in the morning, officers conducted a traffic stop for failing to signal prior to lane change and traveling at a high rate of speed. Defendant was identified as the driver. He had bloodshot eyes, strong odor of alcohol in his breath, and he admitted to drinking alcoholic beverages. They conducted the standard field sobriety tests, 6 of 6 for the HGM, 3 of 8 for the walk and turn, 2 of 4 for the one leg stand. The IC was read, breath was refused, and a blood warrant was executed and blood was drawn.
Okay. Any prior DWIs?
No, Your Honor. However, the officers did find a 12-ounce, 3/4 empty bottle of Seagram wine cooler in the backseat floorboard.
Is he charged with the open container?
I don't believe so.
You need to understand that if officers find an open container in your car, it's a minimum of 5 days in jail flat to any sentence that is given when you're charged with DWI. Mr. Butler, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you consume alcohol and kind of dope, I'll revoke your bond, put you in jail. You will not get any more PR bonds.
All right, sir.
You understand?
Your Honor, I had a letter that was written by the upper administration at the university that I work for. I wanted to present it to you.
You need a lawyer. I can't really talk to you about the case, you know. There's always two sides to the story. I get it, but I can't take a document from you without presenting it to the DA, and anything you say they're going to use against you, whether it's spoken, written, you know, Swahili, whatever it is. So it's, at this point, you'll get the opportunity to fight your case. Just now's not the time. The only thing I'm going to advise you is that this is a DWI. There's a lot of timing requirements. So you need a lawyer to represent you with this, because there's a lot of timing requirements where you may potentially lose your license. So we're going to give you 30 days to hire a lawyer, but don't wait that. Get on it quick.
Sorry.
So I will have you first meet with Victoria. We'll have you sign a reset. After that, you'll get with Rachel for your bond conditions. And after that, you'll be free to go. Okay? Good, sir.
Okay. All right, Judge, next is page 4, Cabrera, Giovanni, come on up.
Good morning, Mr. Cabrera. Sir, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On August 9th, officers were dispatched to a terrorist threat call at a home. Complainant stated he was cleaning the outside of his home. When the defendant grabbed the garbage can and threw it at the complainant's vehicle. The complainant got in his car to go to the store, and then the defendant got in the way of his car, so he couldn't leave the driveway. Complainant then went into his garage. The defendant started making cat noises and called the complainant a pussy and stated, "I am going to whoop your ass." The complainant ignored the defendant in order to avoid an altercation, but the defendant got closer to the garage and continued his taunting. The complainant stated that he was in fear for his safety. A witness stated that she saw the defendant tell the complainant that he wants to have a one-on-one fight. And the defendant stated that they were just having a family feud.
The relationship here, are they just next door neighbors? Do you know?
I'm not sure, Your Honor. The victims didn't clarify what the relationship between the parties were.
Okay. Mr. Cabrera, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person and not to go within 200 feet of where they live or where they work. Do you understand? If you violate these conditions, I will put you in jail. You will not get any PR bond, sir. No weapons is part of this agreement as well. We're going to reset your case to give you time to hire a lawyer. So first, I'm going to have you go to Victoria, sign a reset. After that, I'll have you take a seat in the jury box while we get your bond conditions, while you sign it, and then you'll be free to go, sir.
All right, Judge, next is page 5, Cummings, come on up.
Hey, Damien, what's up, man?
How you been?
And you're on a specific case or what?
Huh? I just came here to talk to us. Yeah, you about to go up to 13 years. Yeah.
Good morning, Mr. Cummings.
Morning, Jack.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Cummings. Yeah, Derek Cummings.
Officers were dispatched to a 3-car wreck. The reportee advised that she was rear-ended by a white Volvo while she was sitting at the light. This pushed her into another vehicle, which was in front of her. That other vehicle left the scene before the officers arrived. The officers met with the defendant, who was already out of his vehicle and searching for something on his passenger seat. Officers smelled the strong odor of alcohol in his breath and observed that he had glassy red eyes and he was unable to balance. The defendant was detained because he could not stand on his own. He advised that he was driving back to his apartment after watching a fight. They conducted the standard field sobriety tests, 6 to 6 for the HGN. Defendant refused the walk and turn in one leg stand. Officers read the DIC. Breath was refused, blunt warrant was executed, blood was drawn.
He's on felony bond for an evading arrest in a motor vehicle.
Yes,
Yes,
sir.
sir.
It's set for trial next month.
Is there an order in that case not to drive?
Just to be sure.
Mr. Cummings, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license, sir?
Yes, sir.
Do you have valid liability insurance in your name?
Yes, sir.
Can you run his license, please?
Sure.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming anything, I will put you in jail. You understand?
Yes, sir.
You will not get any more PR bonds from us. You're on felony bond for an evading in a motor vehicle. It's very possible they revoke that and put you in jail. So I would be on the lookout for that. Do you understand?
Yes, sir.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset.
It's eligible.
Okay, then you will get the rate for your bond conditions, then we'll send you on your way. Don't pick up any new cases. Do you understand?
Yes, sir.
All right.
Do not have a no driving condition. All he had was what he gave him, there's no arguing.
Got it.
All right, Judge, page 6, Danby, come on up.
Mr. Balanchine,
Morning, Judge. How are you?
you were here first, so I wanted to hit you first.
I appreciate it. We were
No.
just trying to take care of some business with.
Housekeeping?
Yes.
So is this Ms. Denby, right?
Yes.
Good morning, Ms. Denby. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one, and one will be appointed to you, ma'am.
The complainant and the defendant are in a dating relationship. On August 4th, 2024, officers were dispatched in reference to a family disturbance. Dispatch heard a verbal disturbance over the phone. This defendant stated that they were out celebrating complainant's birthday. When they had a verbal disagreement, the defendant left the location in an Uber. The defendant was on the porch with her daughter drinking wine when the complainant arrived. Complainant went up to defendant, took complainant's phone, placed it in his pocket. Defendant attacked complainant by scratching his face. Complainant placed the phone on the table and went upstairs. Defendant followed him while yelling. Complainant barricaded himself in the child's room, and defendant continued to bang on the door and yell obscenities at the complainant. Complainant opened up the door. The defendant charged at him and continued to attack. Complainant was able to move defendant out of the way and go downstairs. The complainant felt pain on his face and called 911, and the officers saw visible injuries on his face.
So alcohol was a factor.
Yes, Your Honor.
Okay. Ms. Denby, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming any kind of dope or alcohol, I will put you in jail. You will not get any more PR bonds. Do you understand? Tell me about the relationship, Mr. Balanchine. Is that something?
They've got 3 children, 11, 9, and 6.
Does he want to have contact with her?
I still want to have contact. He's here this morning. He's already met with the
Okay.
deputy prosecutor.
Okay. You've verified that?
Yes, Your Honor. David came up, this is what David was talking to me about a second ago.
So, Ms. Denby, let me see. I am entering in what's called a magistrate's order of emergency protection that identifies Britton Denby as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. This usually comes with a residential restriction, meaning that you cannot go within 200 feet of the residence. I will take that off. So my wishes always are to honor the wishes of the complaining witness in any case. And if they want to have contact with you, I will allow that. But I am ordering you not to have any threatening or harassing contact with him. I don't know what kind of relationship you have with him. If it's the kind that you're constantly butting heads, that you're constantly fighting, that you can't get along, then I would be very careful, because the slightest thing you do will land you in jail. Understand what is threatening or harassing doesn't matter what you think. I could care less what you think. It's what they perceive. So can conduct alone violate this? If I go like this, is that threatening or harassing? It most certainly is. So that's why I'm telling you, be careful. There's a lot of vindictive people here. There's a lot of mean people in this world. And there's a lot of people that will hold it against you. So you're the one that's gonna be on the losing end of that. Do you understand? no threatening, harassing, no weapons, no alcohol, no dope. And as long as you can abide by that, you'll be fine with us. Do you have any questions? Okay, so for now, what we'll do is I will have you meet with, first I'll have you meet with Victoria to sign a reset. You will eventually meet with Rachel for your bond conditions. After that, you guys will be free to go. One more thing. I am going to waive your appearance because you have a lawyer, so you don't have to waste your time coming to court. But you must stay in touch with Mr. Balanchi. He will tell you if and when you have to come back to court. If he tells me that he can't get a hold of you because you're playing games and not responding to phone calls, text messages, I will issue a warrant for your arrest. All right? Okay, guys. Good luck.
All right, Judge, next.
Mr. Balanchi, I will take off the residence. That way you guys can have a copy of this. And,
I'll call her.
for sure, of course. Thanks for being patient.
All right, Judge, next is page 6.
Yeah.
Page 6, David, come on up.
You can't tell me what to do.
Sorry for my time, y'all.
Good morning, sir.
Sorry for my time. I didn't know, I got short.
I'm glad you made it. But, or you wearing
Yeah,
shorts?
I'm really short.
Okay.
I couldn't get
Next time, don't. Okay. Well,
Page 6, Your Honor. Davis.
okay. All right. Well, good morning, Mr. Davis. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Hey, please. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Your Honor, on January 3rd, 2024, in Harris County, officers were dispatched to an apartment complex. The call slip stated the reporting was hit by her boyfriend. Officers met with the complainant witness. The complainant and the defendant are in a dating relationship and live together. The complainant was trying to sleep and the defendant was disturbing her. The complainant asked the defendant to leave and began putting his stuff outside. The defendant hit the complainant in the face, causing pain. Officers noted a bloody laceration on the complainant's lip. The defendant fled on foot before the officers arrived.
So you said he punched her in the face? Is that what he did? Okay. Mr. Davis, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand? I'm also ordering you not to be in possession of weapons as well. If you violate these conditions, you got out of jail because we gave you a free bond. You're not going to get another one. So if you violate these conditions, I'm going to put your bond at $5,000 to $10,000. And if you don't have anyone to pony up that money for you, what happens? You'll be stuck like Chuck, right? So keep that in mind when you're out in the free world, because if you do something boneheaded out there, that's it. A protective order was issued on the 9th of this month. I would get to know it, because if you do something to violate the protective order, the state can and will file an additional case against you of violation of a protective order. It's one of the worst cases you can pick up, because at that point you violate conditions. I can hold you at zero bond in custody. What do you do for a living, sir?
I do handyman work.
Is that a steady income? How much money you make a month? Give me a number. What do you do a month? You want to apply for an appointed lawyer? Okay. I will appoint your lawyer today. I don't want any issues, though. Just behave yourself and have patience. Don't say anything, really. I'm just trying to put you on notice. That's it. Vic, I already have an application on file. So I'm going to have you go to Victoria. We'll have you sign a reset. After that, I'm gonna have you take a seat in the jury box. We'll get your bond conditions. Before you leave here, do not leave until you sign the bond conditions of no contact, no weapons. And then I'm gonna have you talk to someone here momentarily. That's the order for protection. That's what you.
They gave me one for the protective orders and they gave me one for the bond.
Okay. Okay. Well, I'm gonna have you sign one so that I know exactly what it's on file. Okay. All right, please. Is that good enough, Your Highness? Your worshipfulness?
All right, Judge, next is page 7, Diaz, come on up.
Hey, what does this mean?
Yes.
Transito Jimenez. Page 7, Diaz.
Transito Diaz.
Morning, sir.
You speak English, huh?
50%.
Would you like a translator?
Yes, I need very.
Why don't we do it just in case? Great timing, Luis. Wow. Are you clairvoyant? You can go play the lottery. Mr. Diaz, you were charged with terroristic threat. It is of a household or family member. That kicks it up to a Class A misdemeanor. So you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On July 26th, 2024. The plaintiff came to the police station to report that her husband threatened to kill her. They've been separated for 2 years, and she's in the process of filing divorce. The complainant works at a beauty salon. The defendant happens to live at that beauty salon. The defendant turned the water off at the salon and threatened that he would kill her, and that he didn't care if he went to jail. The complainant stated that she is afraid of defendant and that he has threatened her in the past. And she was identified by her Texas driver's license. His criminal history does include 2 attempted murders.
I was, for as sweet and as innocent as Mr. Diaz looks, I see a prior aggravated assault, 2 prior attempted murder cases. Tell me, same complaining witness?
The attempted murders are from 1993, so we have no information on them. The system hasn't updated that yet.
See if I can find some. What about the aggravated assault? Can you find anything on that?
He caused bodily harm to a male by using a deadly weapon, deadly a firearm, Your Honor. It was placed under deferred.
Mr. Diaz, I'm going to find that there's probable cause to go forward with your case. I am ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using anything, I will put you in jail. You will not get any more PR bonds. I am ordering you not to have any contact with this person and not to be in possession of weapons. Do you understand the conditions? I don't know who you have in your life, but if you violate this, I'm telling you, Mr. Diaz, I will protect every single person in this county. If that means putting your bond at 200,000, I'm going to do it in a second. You are on notice now. No contact means no contact from any means. Phone calls, text messages, smoke signals. social media. Do you understand? So this is not the proper time. I have a bunch of district attorneys in here, and everything you say, they're going to use it against you. Tell me, how old are you, Mr. Diaz? Are you employed at this moment?
Ya tengo el negocio. Soy el dueño de la propiedad.
I'm the owner of that property.
So you have income then?
Not now, because the economy is broke.
You're telling me that you own several properties. What does that mean?
No,
Or you have several businesses?
no. Son de mis hijos.
My children.
Son de mis hijos.
What did he just tell you? That he,
He owns that business, the property for the.
It's ours, it's the family.
so this is a family business then? How much do you earn from the family business a month?
500, 600.
500, 600.
Yep.
The complainant also works through your honor.
500 or 600 what? 1,000?
No, al mes, porque ahorita trabajo.
$500,
We open just
$600 a
only
month.
5 hours a day. We open just 4 hours a day. We close early because the business is not good. They only stay there because the property is ours property. That's why we don't pay rent.
Okay, I will give you an application, but I want to know everything about you. I want to know what kind of car you drive, stocks, bonds, IRAs, how much money you have in the bank, how many bank accounts you have, how many businesses you have, what kind of property, if you have any houses, trailers. I need to know everything about you, and then I'll take a look at your financials to see whether you qualify for an appointed lawyer. Mr. Diaz, no contact. Do you understand?
No, this is not happening, nothing, because the officer's coming.
I'm not going to talk to you about the case. All I want you to understand is that I'm ordering you not to have contact with.
Yeah, I understand that.
All right.
I understand.
So deputy will give you an application. I will have you fill out a reset, and then we will have you take a seat in the jury box while we have you fill that out, sir. And then Logan, if you can follow those conditions. Yeah, I guess, yeah, no, that's a good idea. I forgot about it. I'll do it on the come around.
Fernandez, come on up.
Okay, no, hold on, Mr. Diaz, one more thing, sorry, Luis. I'm going to do one more thing, Mr. Diaz. I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Leticia Segura as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of 4690 Burke Road, apartment 61. If you violate this court order, listen. I want you to listen, and you can talk to me later. This is a court order that I expect you to live by. And if you violate this, the state will file an additional charge against you. This is a protective order where you cannot go within 200 feet of where she lives or where she works. Do you understand? She can work there. You just can't go there.
I don't go, but stay beside me. The restaurant.
You're not within 200 feet, then you will be fine. I will have you speak to a lawyer today. All right, I don't want there to be any issues, and I'm not gonna set you up to fail, okay? So I'll have you speak to someone and we'll get down to it. Okay? All right. Jayla Hernandez. Ms. Hernandez, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
The defendant and her 14-year-old companion placed the following items in bags and proceeded to walk past all points of sale. The total value was $748.93. The items were 5 Lego sets and 2 headphones.
Your dad. Thank you so much for coming. Do you know what she's charged with? She's charged with theft. She's facing up to 6 months in jail and or a $2,000 fine. Looks like it's from Target, and you said it's around over $700.
Yeah, that's $48, Your Honor.
Okay. Who is the 14-year-old companion?
I don't have her initials, Your Honor. I assume it's probably her sister. JM.
Is that right?
No, it's one of her friends.
Okay. Ms. Hernandez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go back to any Target. You understand? If I find that you go back to Target, I'm going to put you in jail. You will not get any more PR bonds. How old are you? What do you do for a living, man? A theft case is probably one of the worst cases that you can pick up. When you are branded a thief, you'll never get a good job. If you want to apply for any kind of financial aid to go to college, not with the theft conviction. You're 17 and you're shooting yourself in the foot before your life has even started. This is not a smart move. Everyone makes mistakes though, right? We're all human, but the idea is that you learn from the mistake. Because if you don't, you will end up with a perpetual number on your back wearing orange, and it's not a good life to have. I promise you, this life is about 2 things, right? Money and education. And if you don't have either, it's a crappy life. It's hard enough as it is. Everyone wants to see you fail. Everyone wants to see you put down. So you have to rise up against them. This is not the way to do it. Dad, tell me, how can I help?
Like I said,
Because you know her better than I do. Is she out of control? Is she using any kind of marijuana? Is she using anything?
this is very restrictive for her. She has a job, she works at Starbucks and everything. And she just got mixed up with the wrong crowd. And
Perhaps she is the wrong crowd. She's with a 14-year-old girl. She's 17. You're the one that's near the adult, not the 14-year-old. You know, when people tell me, man, I was with the wrong person, baloney. Could be that you are the wrong person. There are no mistakes. There are choices. That's what it is. You didn't make a mistake. This is a choice. If I drug test you right now, what's going to show up? Are you sure? I'm sending you right now. I want to send it for a drug test. I want to see what, if anything, is in there. And then I'm going to have you, I want you to come back. You're ordered to come back. If you don't, I'll issue a warrant. I'm going to make your bond sky high. I'm sending you for a drug test. I want to know what, if anything, is in your system. And then we'll talk when you get back. I will give you a lawyer and I will pay for everything for you so you won't have to pay anything out of your pocket. Okay? I'll help you out as much as I can. But first things first, let's see if she's clean or not. That's what I want to know. And assuming if she's clean, we'll go from there. If not, we'll find a different attack route. Huh?
okay.
Okay. So if you just guys want to hang out with me, I'm going to have Rachel get with you for a second, send you for a drug test, and then we'll have you come right back. Okay? All right. Thanks.
I don't think Dad liked what he heard right there.
All right, just a minute. Page 10.
That
Jackson,
he
Victoria,
is the wrong crowd. I don't think he liked that. hearing that, but sometimes you gotta hear the tough stuff. Not sometimes, you gotta hear the tough stuff. That's how you get better and do better. She don't have no teeth.
Good morning, Ms. Jackson. Ma'am, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine.
She on that drugs. Your
Looks
mind
like probable
on that.
cause has already been found in your case. Why is it that you don't show up to court? Why is it that you don't show up to court?
Vehicles broke.
So just because of that, you can't show up?
Oh, that's not a show.
If you ever fail to show up, I will make your bond so high that you will be stuck in custody. You will not get any more PR bonds. Do you understand me? Vic, can you? Actually, we haven't done probable cause. We're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. Okay, Logan, please.
Thank you, Your Honor.
Please.
On June 16th, 2024, officers were dispatched to a disturbance at a Swift gas station. Officers met with the complainant, who stated that he's an employee and he's a stranger to the defendant.
You said he's no stranger to the event?
He is a stranger.
Oh, he is, okay.
The complainant said that they have a problem with vagrants still leaving trash everywhere. He stated that he approached the defendant, asked her to be mindful. She got upset, threatened to kill him, and became further upset and struck him 3 times with a fist in the lip, causing him to feel pain.
That,
Yes, Your Honor.
Ms. Jackson, I'm gonna find that there's probable cause to go forward. I'm ordering you not to go back to this location. Do you understand? I'm gonna have you sign a reset, and then I'm gonna have you take a seat in the jury box while I find you a lawyer, man. Please.
All right, Judge, next is page 11, Jones. Gerald, come on up.
You say this is Gerald Jones? Mr. Jones, do you have a lawyer today?
No, sir.
Your case is 1,533 days old. I'm gonna appoint you a lawyer and we figure out what happens with your case today. Take a seat for me in the jury box.
All right, Judge, next is page 13, Clark.
Good morning, Ms. Parks.
Oh, good morning.
Ma'am, you're charged with discharging a firearm in the metropolitan area. You're facing up to a year in jail and or a $4,000 fine. We're gonna do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. ma'am.
Thank you, Your Honor. On August 9th, 2024, officers were dispatched to a residence where they met with a resident who was concerned about someone firing a gun along the fence area, which separates the properties. She stated the 2 white males were walking along the fence line when she heard the gunshot. Officers observed a vehicle with a white male pull into the property. That man stated he lived there and he had a roommate. Officers detained the roommate, who was another white male, and recovered a 9mm Luger spent casing from where the witness said that she heard the gunshot. The detained man told the officers that the defendant was the one shooting because she was trying to learn how to handle a gun. She had just got the gun and was learning how to clean, oil, and shoot it. That man advised officers that she fired it after oiling it in order to ensure that it would not jam. She just fired it to the ground. The detained man pointed her out, and the defendant stated that she had ordered a gun, but it had not arrived yet.
She ordered a gun?
Yes, Your Honor.
She has a felony conviction.
Yes, Your Honor. She consented to a search of the property, and there was a black and silver Taurus with extended magazine in plain view. One round had been fired from that gun. The address is within the city limits of Houston.
Understand what, I mean, you should be charged with felon in possession of a weapon, man.
What a
You're looking
dumbass.
at
Why would you
a
do that?
minimum of 2
Why?
years, a maximum of 10 years in prison. You have a felony conviction. You're not allowed to have a weapon. Do you understand?
Yes, I do.
This is what a dumbass looks
You're going to
like.
find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of weapons, ma'am. What do you do for a living? How much money do you make a month?
Maybe around like, it depends. It's up and down.
On average, what do you make a month?
Pardon?
On average, what do you make a month?
I'm gonna say it's like around maybe about 15, maybe.
Okay, and where do you live?
I stay off of the southwest side
Live with?
myself.
Pay rent? Do you?
Yes.
Trying to determine whether you need a court-appointed lawyer or whether you have the ability to hire a lawyer on your own. That's why I'm asking these questions.
Okay.
If you're going to give me vague and just non-responsive answers, I'm just going to reset your case to give you time to go hire a lawyer. Is that what you'd like to do? Okay. I am ordering you, like I said, no weapons whatsoever. If you violate these conditions, I will put you in jail. And like I said earlier, you should be charged with a felony offense. It's very possible that they sit there and indict you. So I would be very, very careful. And I would also get a lawyer as quick as
What a
possible.
dumbass. How do you go
I'm gonna have you go to Victoria, sign a
You're a
reset. I'm
felon
gonna have you
and
then
you
take a
order
seat in the
a
jury
damn
box while we
weapon,
get your bond
but then
conditions.
you
We'll have
pull
you
out a
sign it and
weapon
then you'll
on
be free to go.
somebody. Smart at all, not smart.
17, Smiley, come on up.
That the wording is in my face.
Okay, so this is the one Frederick's guy. Frederick was here yesterday, remember?
Is he on Zoom? I think he said he was gonna Zoom on, right?
I don't know. All right, good morning, Mr. Smiley. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On August 9th, 2024, officers observed a motorcycle going 120 miles per hour in a 65-mile-per-hour zone.
120.
Yes, Your Honor. The motorcycle had no rear license plate and unauthorized lighting. Officers attempted to conduct a traffic stop, but the defendant drove away and began to evade at a high rate of speed, ultimately getting up to 122 miles per hour. He ran multiple lights and was driving in between vehicles. A police vehicle shadowed behind and visual was maintained by a helicopter. The total pursuit was 9.96 miles. The defendant then pulled into a gas station. Officers attempted to stop the driver there, but he again pulled away. Eventually, he ended up at a dead end where he dumped the motorcycle and hid in the woods. Officers set up a perimeter and canines located the defendant. The defendant had an empty firearm holster on his waist. The firearm was in a nearby bush. It was a black Glock Gen 5 9mm. The defendant admitted to throwing it into the bush.
Mr. Smiley, I'm going to find that there's probable cause to go forward with your case. Can you imagine at 122 miles per hour, if you fall off the bike, what's going to happen? What's going to happen? No more Mr. Smiley, Mr. Frowny. That's what's going to happen.
Not Mr.
You'll be
Frowny.
carnage on the side of the road at 122 miles an hour. You'll be mangled garbage on the side of the road, Mr. Smiley. And all that has to happen is the slightest. I am taking away your privilege to drive. I don't care what is going on in your life. You will be signing an affidavit with me today, promising me you're not going to drive. I don't care what it is, a moped, a motorcycle. If I find that you drive, I will have a contempt hearing You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? This is an affidavit that you will also promise to me that you're not to be in possession of weapons. One false move, you'll be spending a lot of time with me. And I'm not a fun person to hang out with. Do you understand?
Hello?
What date are the felonies set for? Do you- We are going to put your case for the same day as the felonies that are set for. What do you do for a living, Mr. Smiley? Doing what? So it's a full-time job. Okay, I'm gonna have you come up here, swear to us that you're not gonna drive, that you're not gonna be in possession of weapons, and then you'll be on your way. It is your responsibility to stay in touch with Frederick. If he tells me that he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. I promise you now, there are no more PR bonds for you. Do you understand? I will do everything in my power to protect Harris County. At 120, if you would have hit someone, you would have killed them. And then you're charged with vehicular homicide. Think before you act.
Next is page 2122, Washington. Come on up.
Michael Washington. Mr. Washington, you're charged with reckless driving. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing a year. On your other case, you're facing up to 30 days and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On August 8th, 2004, officers observed a street takeover in a parking lot of the Restaurant Depot on West 20th Street. Approximately 80 to 100 vehicles were there. Undercover officers observed the suspect vehicle to do two donuts within 10 feet of the light pole inside the parking lot, maintain visuals on the car until a marked unit could conduct a traffic stop. The driver was identified as the defendant, and the defendant had a little passenger in his car with a Glock in the glove compartment.
Mr. Washington, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license? Liability insurance.
Yes, sir.
I'm ordering you now as a condition of your bond not to participate in any more street takeovers, reckless driving, donuts, anything of this nature. If I find that you do, the first thing I will do is I'll put you in jail. The next thing I will take your privilege to drive away from you permanently. Do you understand? Living in a city as big as Houston without the ability to drive blows. It's a privilege, not a right. I'm also ordering you not to be in possession of any weapons as well. How old are you, sir?
21.
What do you do for a living?
Like a lot.
How much money do you make a month? We're going to give you time to hire a lawyer. So I'm first going to have you go to Victoria, sign a reset. After that, I'll have you take a sit in the jury box while I get your bond conditions. We'll have you sign it, and then you'll be free to go. No more boneheaded move out there. Do you understand?
Yes, sir.
Otherwise, I'm gonna keep you.
All right, Judge. Next is page 23, Williams. Come on up. Ms. Denby.
Are you Matasia Williams?
Yes, sir.
Miss Williams, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On October 8th, 2019, officers were dispatched to a one-car accident. The defendant had red, glossy eyes and odor of alcohol on her breath. She admitted to one drink. There were 0 of 6 clues on the HGN because the defendant was crying and kept moving her head. 8 of 8 for the walk and turn. 4 of 4 for the one leg stand. A DIC was read, breath was consented to. The result was 0.089 and 0.089. And she had a prior DWI arrest out of Louisiana.
Not only that, but this case is nearly 1,774 days old. Ma'am, I'm going to find that there's probable cause to go forward with your case. On one ankle, I'm going to put a GPS monitor so where I know where you are at all times. On your other ankle, I'm ordering you to obtain a scram device so I know that you're not consuming alcohol. If I find that you consume anything, and I'm going to tell you now, I already deem you a flight risk because of how old your case is. You
I
ever
didn't know about it.
take off on me again, I will make your bond $50,000. Do you understand?
Yes, but I didn't know about my case.
You were given a general order bond in 2019. You signed stating that you had to come to court. So
That was my first time in trouble. Like, I didn't know anything about none of that.
I have a prior DWI from Louisiana.
I didn't know nothing about that either.
Perhaps therein lies the problem. But I'm now going to put both monitors on you, and I'm giving you a warning. If you consume anything, if you take off on me again, I'm going to make your bond sky
I
high.
take care of my kids. I stay in Houston. I don't do that. My kids have disability. I don't go anywhere. That was years ago. I'm not even that type of person anymore. I take care of my kids. I stay home. That's literally what I do. That was when I was partying. I'm not that type of person anymore.
You know how many people tell me that the sky and the moon are black when I come in here? All I know is you have a prior DWI and your case now is 1,700, nearly 1,800 days old. We set cases for trial at 180 days. Your case is 100 days times past that. Do you have an income, Ms. Williams?
Of the sexual organ of Elise Morwick, a child, by Jose Del Bosque's sexual organ, then you will find the defendant guilty of the lesser included offense of sexual assault of a child and count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of sexual assault of a child and count 2. Eight, count 4. Now, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of March, 2021 in Bexar County, Texas, the defendant, Jose Del Bosque, did intentionally or knowingly cause the sexual organ of Elise Morwick, a child, to contact the mouth of Jose Del Bosque, and with the intent of facilitating the commission of the offense, Jose Del Bosque provided alcohol to Elise Morwick, which was a substance capable of impairing Elise Morwick's ability to appraise the nature of the above described act or to resist the above described act, then you will find the defendant guilty of the offense of aggravated sexual assault of a child as charged in count 4 of the indictment, and do not consider paragraph 9, but continue on to paragraph 10. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of aggravated sexual assault of a child as charged in count 4 of the indictment, say by your verdict not guilty of aggravated sexual assault of a child in count 4, and next consider whether the defendant is guilty of the lesser included offense of sexual assault of a child in count 4 as instructed in paragraph 9. 9, count 4, lesser included offense. Now, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of March 2021 in Bear County, Texas, the defendant, Jose Del Bosque, did intentionally or knowingly cause the sexual organ of Elise Morwick, a child, to contact the mouth of Jose Del Bosque, then you will find the defendant guilty of the lesser included offense of sexual assault of a child and count 4 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of sexual assault of a child in count 4. 10, count 5. Now, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of March 2021 in Bear County, Texas, the defendant, Jose Del Bosque, did intentionally or knowingly cause the penetration of the sexual organ of Elise Morwick, a child, by Jose Del Bosque's finger, and with the intent of facilitating the commission of the offense, Jose Del Bosque provided alcohol to Elise Morwick, which was a substance capable of impairing Elise Morwick's ability to appraise the nature of the above described act or to resist the above described act, then you will find the defendant guilty of the offense of aggravated sexual assault of a child as charged in count 5 of the indictment, and do not consider paragraph 11. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of aggravated sexual assault of a child as charged in count 5 of the indictment, say by your verdict, not guilty of aggravated sexual assault of a child in count 5, and next consider whether the defendant is guilty of the lesser included offense of sexual assault of a child in count 5 as instructed in paragraph 11. 11, count 5, lesser included offense. Now, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of March 2021 in Bear County, Texas, the defendant, Jose Del Bosque, did intentionally or knowingly cause the penetration of the sexual organ of Elise Morwick, a child, by Jose Del Bosque's finger, then you will find the defendant guilty of the lesser included offense of sexual assault of a child in count 5 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of sexual assault of a child in count 5. Your verdict in each count must be unanimous. If there is evidence presented of more than one alleged instance that could constitute an offense committed by the defendant against the complainant, if any, you are instructed that your verdict on each count must be unanimous about which specific instance, if any, constituted the commission of the offense in each of the individual counts. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced into evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or persons connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict on each count, the presiding juror would certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his or her own views and change his or her opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charge beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdicts are attached to the charge for your convenience, if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, each verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this case, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you retire to the jury room, No one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Attached are suitable verdict forms. Are parties ready to proceed with closing arguments?
Yes, Your Honor. Yes, ready.
All right, each side, you have 20 minutes. State, you may proceed.
Thank you, Your Honor. Quote, there are a lot of families that depend on me. It would be a disaster. I didn't force anything. I almost always start my closings in these cases with quotes from the victim, but the defendant's words are so deceptively despicable, I wanted to lead off with his words, right? These are the words of a 49-year-old man at the time with 2 daughters of his own, right? Who did something to someone else's daughter that I would shudder to think he would want to happen to his own children, okay? It would be a disaster. I didn't force anything. You know what's a disaster? What's truly sad and heartbreaking? You know what forced a now 20-year-old to get up on the stand to talk about a sexual assault that happened with someone 3 times her age? How about these quotes? He took my pants off. He bent me over the counter. He started having sex with me. He put his penis in my vagina and my anus. It hurt. Did he use a condom? No. Did he use lube? I don't think so. We ended up in his bedroom. We had more sex. He was touching me all over. His mouth was on my vagina. His mouth was on my breasts. That is aggravated sexual assault of a child, okay? And the aggravating element here, in the defendant's own words, when he took the stand on direct examination with his attorney, yeah, I met her at the gas station and I gave it to her, it being the 6-pack of hard seltzers, okay? Now, I want to talk to you very briefly about the jury charge, the same charge counsel has and my partner has, okay? So this is the law as not written by the state of Texas. This law is not written by the defense. It's provided by the court, but this is provided by the state of Texas. This is the law under the state of Texas, okay? So it outlines the counts, right? So it says count one, lesser included. I'll get to that. Count 2, and it goes all the way to count 5, okay? It goes count 1, 2, 4, and 5. Now, the state of Texas chose not to proceed on count 3 because her words were, he tried to put his penis in my mouth, and that's when I got myself together and put my clothes back on. Okay, so we're not moving forward on count 3. We have counts 1, 2, 4, and 5, and they're just written right at the top of the page, okay? Now, briefly, let's go into what a lesser included is, right? So you have count 1, lesser included. Count 2, lesser included. Everything you see in this packet is about aggravated sexual assault of a child, except for the lesser includeds. You know what those are? Sexual assault of a child, but no alcohol. So for some reason, you're like, Zach, look, even in his own words, there was the furnishing of alcohol, but you, for some reason, don't want to go forward down the path of the facilitation or the providing of alcohol. You have count 1, aggravated sexual assault of a child, aggravating meaning alcohol. But if you're like, Zach, forget the alcohol, no way, fine. You have count 1, lesser included. The lesser included here is sexual assault of a child. There's not going to be any mention of alcohol. Does that make sense to everyone? You have aggravated sexual assault, 1, 2, 4, and 5. No alcohol, sexual assault of a child, 1, 2, 4, and 5. Okay? Now, on page 11, you're going to see something with respect to unanimity. Okay? It's going to talk about your verdict in each count must be unanimous. Okay? What I just want to make super, super, super clear is that it's about each individual count. Okay? So when you look at these, and thankfully the pagination works out quite cleanly. Count 1, that's page 3. So you need to be unanimous to this page. Either unanimously guilty, which is what we hope you find, or unanimously not guilty, and then you move on, right? Does that make sense? So it's not, okay, we all have to agree on 1, 2, 4, and 5. Let's take it as one big block. Absolutely not. Take it count by count. You have to be unanimous with respect to each individual count. Once you have that unanimous either way, go on to the next one. All right, does that make sense? And a final thing, just to be super clear, mistake of age is not a defense. So think about the societal repercussions if someone could get up on the stand hypothetically and say, well, hey, I thought she was 18 at the time. It doesn't matter. Unequivocally, without hesitation or pause, know that these laws are passed in the state of Texas to do one thing: protect children so they don't have to take the stand in the first place. Okay? I'll reserve the rest of my time, Your Honor.
Thank you. Defense?
May it please the court. Good morning, we the people. Because the Sixth Amendment of the Constitution starts with the term "we the people." Sixth Amendment gives the person the right to a jury trial. That's why you're all here, all right? So, with that in mind, let's talk about the case. A child who's got a fake ID, a child who goes to bars, drinks alcohol in bars, takes selfies of drinking alcohol in bars, who's holding herself out at least 21 to get into bar. Apparently she looks the age, all right? So what do we have? We have a situation where they talk about getting alcohol. You got to remember, the charge is very clear. It says facilitating the commission of the offense. That means that the defendant, Mr. Del Bosque, had to know that he was buying this 6-pack of Truly so he could have sex with her. That's what they've got to prove. I don't think that's what they proved. What they proved is he bought some Truly and some beer for a house party of at least 10 people. That's what they proved. They didn't prove any intent that he was going to buy this liquor to have sex with her. And that's what they got to prove for aggravated sexual assault on all accounts. All right. So let's talk about what evidence there is about alcohol. They found one bottle or can of Truly that she drank at the house. One bottle. Okay. Every law enforcement officer who testified did not reference the fact that they believed she was intoxicated. These are individuals, traffic cops, who work the streets, who pull people over for DWI, and they know how to identify intoxicated people. Not one of them testified, yeah, when we started talking to her, we noticed she was intoxicated. No, they didn't say that. What they said was she kind of shut up. Why did she shut up? Well, maybe this was a girl, 16 going on 30, that thought about, maybe I'm going to hook up with an older man. She met him at the gas station. They got in his car, driving to the house. She's showing pictures of him of her cocktailing at a bar. They get to the house. They have a drink. Don't even know if she drank the whole drink. The bottle of Truly wasn't brought into evidence to see how much was in it or whatever. What we had was a swab from it that said she drank a drink. Okay. All right. So she gets to the house. She's got her cell phone. Cell phone to the point of, this is cell phone selfie girl, remember? Bars, everything else. Hey, look at me, Instagram. I'm posted. She's got her phone. All she had to do was pick up the phone. I'm being raped. 911. You heard the testimony that the phone kept on going off and off and off and off. Maybe it was the people at the party looking where she went. All she had to do was pick up the phone and say, hey, I'm in trouble. No, that didn't happen. She made no calls. She didn't call Uber. She didn't call the police. What finally happened was Mr. Dabasco gets pulled over for a traffic violation. She's in the car. It starts hitting the fan. She doesn't know what to do. Officer, he kidnapped me. He raped me. No, that wasn't thinking. She's thinking, what am I going to, how am I going to explain this? How am I going to explain this? Her mom shows up. My sweet little innocent daughter was raped.
I'm gonna object to proper argument, Your Honor.
All right, ladies and gentlemen, that objection will be overruled. You'll remember the evidence as you've heard it. You may proceed.
Okay. So when she's giving that statement to the same nurse, what's in her mind? Mom's there outside. I don't want mom to find out that maybe what I did. So I'm going to be very, very specific as to what happened. But on the stand, she wasn't really that specific, if you recall. So the question is, yeah, it's a child according to the laws of the state of Texas. One size fits all. Would you call that person a child? Does a child have a fake ID? Does a child sit in a bar? Does a child drink alcohol? I don't think the state of Texas was thinking about that when they made that definition. It wasn't sexual, what's the term I want to use? It wasn't a forced sexual assault. She willingly got in the car with him. She willingly went to the house. She willingly had sex. He didn't get her drunk for the purposes of sex. There's no evidence that that happened. There's evidence of a couple bottles or a 6-pack of Truly and some beer and a bottle that was drank at the house. So, ladies and gentlemen of the jury, there is absolutely no evidence of aggravated sexual assault because there's no evidence that he facilitated the alleged offense by getting her drunk, because that's what you got to find. It just ain't there. Okay. Now, let's talk about the specific other elements. She claimed that there were other acts of sex besides the one act in the anus. Mr. Del Bosco said, no, that's the only sex we had. So then you go to look at the credibility of the witnesses, all right? You have one girl who, for all practical purposes, is a liar. Hey, I got a false ID. I'm gaming the system. I'm 16 years old, but I'm sitting here drinking in a bar. And you got somebody who's made a mistake based upon a belief, based upon a representation, based upon, hey, you know, she's in a bar drinking. Yeah, I don't know what was going through this girl's mind. I don't know what her family situation was. I don't know whether she wanted to be older than she was. And there's a lot of things, but I do believe, based upon the evidence, that it was consensual. However, you know the story on that. So, with that in mind, let's talk about DNA. Yeah, there was some DNA floating around, but you remember that was also an unknown factor, an unknown specimen brought up. I don't know what this girl was up to. But, there is evidence. Now, also, I believe the SANE nurse, or not the SANE nurse, the first DNA person who testified, she said they did not find any semen on the vulva on her spray. All right. She claimed they had sex, vaginal sex, but they found no semen in her. Don't know. They're going to make a big deal about the selfie. Who in their right mind that they think they're going to get raped is doing a selfie? Hey, Instagram, look at me. I'm toast. You can, if you got kids, if you do Instagram and stuff, TikTok, people are stupid when you put a cell phone camera in their hand. They're taking pictures, they're doing stupid things. I don't think she was that drunk. I don't think she was drunk at all. She was sober enough, drive to the Valero station, sober enough to leave the party once. Remember? Dad shows up, busts the party. They scatter. Dad leaves. They all come back. They hang around for a couple hours. She gets in the car and says, hey, I'm going somewhere. Drives to Valero, hooks up with Mr. Del Bosque. All right. So, sober enough to leave and come back to a party, sober enough to get in the car and drive away. And there's absolutely no evidence of how much she had to drink, where the alcohol came from. You're telling me they got a house party with 10 people and they shared 6, 7 drinks? I don't know, but I don't think she was intoxicated this entire time. She had her cell phone handy. She could have made phone calls. People were calling her. You heard Mr. Labasco say that the phone was buzzing off the hook. It's her friends. Where are you? Where are you? What are you doing? I'm busy. I ain't gonna take your call right now. So, ladies and gentlemen, I don't believe there's sufficient evidence to find any other count guilty except for the one that Mr. Del Bosque admitted to do. He admitted, yeah, he did it. He stood up there and said, I did it. I had sex with her in the anus. I thought she was older. She represented herself was older. I don't think there's any other evidence to prove, credible evidence to prove that they had sex in the vagina, that he had oral sex with her, that he fingered her. All right. Did we hear any evidence of penetration with the finger? No. Did we hear any evidence that she had her underwear off when this happened? Was it through the underwear? Was it? No, there's no evidence of that. So I would assert to you, ladies and gentlemen, that based upon the evidence, the only thing I can see that potentially could be a factor is the first count. And alcohol was not the facilitation of that issue. He didn't get her drunk to have sex with her. And that's what the state's got to prove. And there's absolutely no evidence of that. Thank you, ladies and gentlemen of the jury. I appreciate your service. And thank you once again.
State, you have 15 minutes.
Thank you, Judge. All I just heard was a lot of victim blaming, and you should be outraged. Blaming this 16-year-old girl for what that 49-year-old man did to her. How dare he? Let's talk about these arguments. You heard him say on the stand in a very memorable testimony, he didn't know how old Elise was. He didn't know how old Olivia was. That's bull, and we all know it. He dated Trisha for 5 years. He was in that girl's life through puberty. He met her when she was 11. Olivia was 16 when all this went down.
Judge, I'm gonna object. There is no evidence in front of the jury how old Olivia was. She's arguing.
His
facts
client
that
said
are not
that
in
she was
Stop.
16.
All right, so everyone, direct your objections to the court. Defense, I've heard your objection. Ladies and gentlemen of the jury, evidence was presented to you, and you will remember the evidence as you've received it. Does everyone understand? You may proceed.
A man who had raised 2 daughters, who were now 25 and 27, so back then would have been 22 and 24, he can't tell who is a teenager? No. Don't buy it for a minute. He also keeps talking about this fake ID. There is no evidence presented by either side that Mr. Del Bosque even knew she had the fake ID until later. Yes, there was talk of showing her photos, or showing him photos. And yes, Elise says she had the fake ID. That doesn't matter. He himself said he knew her for at least 6 months, possibly up to a year. He never saw a fake ID. What, maybe that night after he's been texting her for weeks, oh, all of a sudden now he gets proof that she's over 18? No. It doesn't matter. There's also all this talk of, oh, he didn't force her to drink. There's no proof she was drunk. That's not what we have to prove. All we have to prove is that he provided a substance capable of impairing her judgment to her. That's all. We don't even have to prove that her judgment was impaired. We just have to show what he admits to, that he gave her alcohol. He saw her drink at El Mirasol. She says he purchased it for her. We know that he bought drinks for the party, and then he himself even said he gave her a drink at the house. He provided alcohol, a substance capable of taking away her ability to understand what's going on. There's also talk during his testimony of, oh, she made the first move. How dare he? Even if she had, it doesn't excuse raping a 16-year-old. So let's briefly talk about consent. You're going to see some slides from Baudire. Under the age of 17 cannot consent, period. It doesn't matter if she texted him. It doesn't matter if she willingly went out to meet him. It does not matter. That is a line in the sand to protect children. It doesn't matter how close to 17 she was. She was 16, period. And again, as I just said, all he has to do is administer or provide. He provided alcohol. No force necessary, no drunkenness necessary. Now let's talk about Elise's story, which I'm also going to show you all the evidence that backs it up. And you get to take what's admitted. So you guys can take back the picture. You can take back the text. And if you have any questions, I encourage you to read the text. Now remember, these are just the texts from that day. You'll also get to take the same exam that Linda Whitty testified about. You also get to take his interview back. Because if there's any questions, those are going to clear them right up. Elise's story that she is stuck through, and is evidence also in the same exam, they met up, got the alcohol, and he kept texting her. And when you flip through and read these, you'll see that he's the one being like, hi, when can we meet up? When are we going to hang out? He pushes it. She doesn't. So I'm going to highlight a few of these. Elise texts him, hey, her dad, meaning Olivia's dad, her dad's just came to the house. And he says, oh, so what now? Well, leaving and coming back then when he leaves. If he doesn't know she's a minor, what does Olivia's dad have to do with anything? Why would that prevent him from going over to the house to hang out? If they're all adults, why does he care if another adult man is there? Because he's a liar, and he's a bad one. You'll also see where he tells her, hey, I got some Truly, some Michelob, let me know when you're ready. Oh, I also have some barefoot wine. Pushing her. And then as he's waiting for her, somebody who's claiming, oh, I have no intention of flirting with her. I have no intention of doing anything sexual. As late as you need, baby. To a 16-year-old. Yeah, no, he didn't mean to do anything. He wasn't planning anything to happen. That's a lie. He knew she was drunk. He knew she'd been drinking, and he pushed her to leave that house. He pushed her not to let him pick her up, even though he knew she'd been drinking. No, he wanted her to leave the house and be picked up somewhere else so no one else would see her leave with him, because he knew what he was doing was wrong. He knew she was a child, and he didn't care. You'll also get the SANE exam. I've just highlighted some things. There's a lot of stuff made about, oh, well, there's nothing about getting food. And she says, no, well, he called me. She says that 3 years ago in the SANE exam. Jose called me and said, I can go for food. Consistency. I thought we were just gonna go get food. He gave me a drink. He started kissing me. He kept having sex with me. He would grab me and keep me from putting my clothes on. He just kept pushing me. I tried to push his arm, but I couldn't push him off me. I kept saying no. Read the narrative. You'll have it back there. And you'll also talk what Linda said, the yes/no questions. Was there penetration of his penis with your vagina? Yes. Was there penetration of his finger in your vagina? Yes. Did his penis go in your anus? Yes. Did his finger go in your anus? Yes. Did your mouth touch his mouth, or did your vagina touch his mouth? Yes. It's all in there. But most importantly, there's this. Here's more evidence that it went into her vagina. The injuries on her hymen and her labia minora. All in there, all documented. Probably the most heartbreaking part. She declined the anal exam. She did not want her parents to know she was assaulted anally. And Linda said that she was so tense and so closed off that she pulled away when Linda tried to touch her. And she told you that that was the most pain she'd ever been in. Because what 16-year-old is going to say, yeah, let me go hook up with this 49-year-old man. You know what we're going to do? We're going to jump straight to anal, no prep, no lube, no condom, and I'm going to be so injured that it hurts. But that's what I'm down for. No, he raped her. He forced her. And it wasn't just the anus, it was also the vagina. And how dare he blame her? The DNA is everywhere. Both of their DNA is on the can. Her DNA is on his penis, along with another person. We don't know who that other person is. Who knows what he was up to, not what Elise was up to. Her DNA is on his hands. His DNA is on her face and mouth swabs. His DNA is on her breast. Male DNA was found in her vagina, but not enough to quantify or test. He wants you to sit here and say, oh, children with fake IDs had it coming. No, she did not have this coming. She did not want this. He raped that child, and you need to find him guilty on all 4 counts and finally hold this grown man responsible for what he did to her.
All right, ladies and gentlemen, Deputy Laura is going to take you to the back.
Mm-mm. I'm coming out, Jordan. No.